Hey there, welcome back to yet another episode in this series of videos where we demystify the Patents Act. As an inventor or an applicant, you may have filed for an application for a patent on your invention. Or best, you may have already received a granted patent on your invention. You know that as a patentee, you are provided with an exclusive rights that governs the usage of your invention by other parties. But what happens to your rights when the government is required to use your invention for its own purpose? Can you exercise your rights as if the government was just another third party? Before we answer that question, let's quickly revise the rights which are provided to us under Section 48. As per Section 48, a patentee is provided with an exclusive right to stop others from making, using, offering for sale, selling, or importing of the patented article for these purposes. Without your consent, third parties are not allowed to use your invention for any of these purposes. But are these rights equally applicable to the government as well? Not exactly. So how exactly? Section 99-103 of the Patents Act help us to understand how the government can use or acquire your invention for its own purposes, and how does it compensate you for such usage or acquisition of your invention. But before we go deep into it, first we need to understand who the government is. As per Section 99, government means the central government or the state government or any government undertaking. Now remember, all the provisions that we are going to talk about the government usage under this section are not applicable to the government usage as we discussed under Section 47. So with this basic definition out of our way, let's move forward with the other sections. So when exactly can the government use the invention? So as per Section 100.1, the invention can be used during the application phase or after a patent has been granted on the invention by the government or any person authorized in writing by the government. Now the next question that comes to our mind is, when does the government need to authorize this person that we are talking about? Interestingly, as per Section 100.4, any person can be authorized to use the invention by the government before or after the patent is granted, and interestingly, before or after such an act or the use of the invention is performed by the person. So we talked about the use of the invention. Can the government also sell such patented goods? Yes. As per Section 100.6, the government also has right to sell such patented goods, but on non-commercial basis. And interestingly, the buyers of such patented goods have no restriction imposed on them just because they have bought the goods from the government or any other person authorized by the government. They are free to use the goods as if they had bought the goods from the patentee himself. So we understood the government is free to use the invention for its own purpose. But when do we inform the patentee that your invention is getting used by the government? So as per Section 100.5, the government is required to inform the patentee as soon as possible about the extent to which the invention is being used. And of course, in case of national emergency or extreme emergency or non-commercial use, the government may take a little longer to inform the patentee about the usage. In case the invention is being used by a government undertaking, then the government may request the government undertaking to provide such an information from time to time basis. Now, during the normal course of the patent term, the patent might have been licensed out or might have been assigned to some other party. In such cases, the government provides such information to such licensees or assigners as well, as per Section 100.7. Great. So the relevant information is passed on to the patentee or the assigner or the exclusive licensee by the government about the uses of the invention.